Very good evening. Welcome to yet another edition of the Democratic Newsroom. Our band of editors are back to discuss a brand new issue. And what is that? Well, a couple of judgments have sparked debate where it comes down to the interpretation of Article 21, which is the right to freedom and liberty. Can there be an interpretation of Article 21 is also a question where bail or jail, and especially where bail comes into question, is it as a right relative and not unconditional? All of that we're going to take forward. If you're just a tad bit confused on what have been the cases, let's just hark back to what happened in Umar Khalid and Sharjeel Imam's bail petition, which was turned down by the Supreme Court, while in the same case of UAPA giving bail to 5 others. And then one day later, you had, of course, a completely different case. It was under PMLA, where the Amtech former chairperson was given bail. But what was to note was the ruling of the bench then, where the bench very clearly said that even a court cannot deny bail on the charge of serious offenses. So let's take it from here. I have a packed house in the Democratic Newsroom, and we're going to begin. Of course, Gaurav Sawant is with us, Akshata, our regulars, but we've got our 2 legal eagles here, Nalini and Anisha, both who cover the courts very closely and know a thing or two more than the 3 of us. So, Nalini, why don't you kickstart the debate?
Well, Preeti, I don't think there's anything left to say about this case that's not already been said on social media, on news channels and newspapers. But I think one thing that we need to remember before we kickstart this discussion is that it's not just the Supreme Court, but 3 different courts who have, one after the other, denied bail to Umar Khalid and Sharjeel Imam. Another important thing to remember that it's a UAPA case that we're talking about. The accused, no matter how influential, no matter how popular, are accused of terrorism. And of course, there are no charges that have been filed in this case. But the third and the most important thing we have to remember is both the prosecution and the accused in this case, who are equally responsible for the trial still not starting in the case. As somebody who's going through regular media reports about what's happening in Karkaduma court with regard to the trial, I can tell you that conclusively, that it's both parties who are responsible. You cannot shift blame on just one, saying it's because of them that the trial's not happened. That's just my opening thoughts.
No, and that was something that was debated in court as well. The prosecution actually held the agreement that the delay of trial, which as per the prosecution, was at the behest of the accused. And on the other hand, the defense had their own, I think, notes to make on that. And Anisha, you'd want to weigh in on the fact that the defense also said that the framing of charges hasn't happened, the witnesses haven't been interrogated, so a lot going on there. But the larger question, Anisha, it's not the problem or the tragedy is not the denial of bail, but the tragedy lies in the fact the inconsistencies of reasoning when it comes to denial of bail in similar cases. Yes, the case that followed was, not a UAPA case, but a PMLA case. But last year, you had a UAPA case under Justice Oka and Justice Masi, and they did give bail, saying very clearly that even UAPA is a charge where you cannot deny bail.
Well, yes, Preeti. Now, if we are talking about this case in specifics, or we're talking about the larger question of the law on bail, we are very clearly
the larger question.
What I'm saying is we are very clearly seeing this sense of inconsistency, unevenness, and a sort of bench-based verdicts coming in. And this is something that the people who've been covering Supreme Court have been analyzing. In fact, the Supreme Court itself has been analyzing this.
It's rule of bench, not rule of law. Depends which bench you get in a similar case.
No, we can't even say that in so many words. The problem is that the law does allow this level of discretion. However, at the same time, we are seeing a situation where instead of following a precedent, now, if you look at this Sharjeel Imam and Umar Khalid case, now look at the Delhi riots case. A 3-judge bench in the K.A. Najib case has very clearly said that if there is a delay in trial, then bail ought to be given. Seriousness of the offence is something that can be considered. However, whether witnesses can be influenced, whether there is any antecedents, whether and all of that can be considered. But if there is delay, then ordinarily give bail. That is a judgment of a 3-judge bench. Now, after that, immediately after that, we've seen in the last 3 years alone, multiple benches either giving bail or denying bail in UAPA cases, in PMLA cases. So we are seeing a very, I would say, when we have a Supreme Court that can speak in multiple voices because these are co-equal benches, we are seeing this situation where whether or not you get bail depends on who is the one hearing your
Exactly, and that's the
matter.
question
And
that has been raised.
that question puts a very, very big question mark on how we're looking at UAPA or
Fair
PMLA
point.
or bail, because remember, both UAPA and PMLA do have specific provisions
And
which
similar
say
provisions.
don't give bail
Similar
unless
provisions
every-
on bail, very different in terms of charges, very different in terms of, because one is just for 7 years, the other one you can even get a death sentence. But when it comes down to provisions of bail, very, very similar.
So that is the thing. Both UAPA and PMLA say that if before granting bail, you look at prima facie evidence. In UAPA, it said that prima facie, if there is evidence, then you don't give bail. PMLA says don't give bail unless prima facie you think the allegation is false. So in this scenario, you've given this kind of discretion, and it is creating this very big question mark. And we've been talking.
There's a fair amount of confusion, and some would call it selective constitutionalism, because Gaurav, if you want to weigh in, it depends what bench you get, as many what seem to suggest. Because same case last year, UAPA bail given can be very different. The role of the accused can be very different than what the perceived role of Umar Khalid and Sharjeel Imam is. Can be very, very different. But it's just seemingly that there is a difference in terms of the judgment on a similar charge.
Well, each crime is different. So each judge is dealing with a crime differently. And it's, I think, a little unfair to say that, different judges give different verdicts on the same sections of law. Because every crime is different. Whatever may have been the crime there, the interpretation there, the circumstances there, and the crimes here. If you don't get a judgment that you want, oh, the judges were bad. If you get the judgment that you want, oh, the judges are very good. That's not the way justice is dispensed with. You go into the merits of the case. And in this particular case, what did the honorable judges say? And they've weighed in and they've explained their judgment. The two gentlemen that you mentioned were architects of the conspiracy. They were masterminds. They were in a commanding authority. They had influence over others. They had a central role. They had an ideological role in this alleged conspiracy. And those who were at the periphery, they were granted bail. So, comparing this to a PMLA case, it doesn't add up, except perhaps for an academic discussion.
But not speaking about a PMLA
national
case.
security involved.
But not speaking about a PMLA case.
This is a very serious national security
But Gaurav, I'm
case.
giving you the example of a case which happened just last year in
That's a
2024 in
different
August.
case.
It was a UAPA case.
It may well be. It may well be.
So, just look at the merits of this particular case. When there's such serious charges of terrorism against Umar Khalid, Sharjeel Imam, are we really going to be debating a case where in the same courtroom, in the same area, you've got other accused also getting bail? And that itself tells you that against these two gentlemen, there are extremely grave, serious charges. So it's not the same. It's not the same, is it? It's very clear, even within the same case, there are layers upon layers, which is what the court has gone into. As far as delay in trial is concerned, I think what Nalini said is very true, that 3 different courts have highlighted that the delay in the trial is also driven by the accused here, by the defense here. So that's another factor that you have to consider. The two constant arguments you hear is, look, UAPA, there are different conditions, there are different aspects of it. But sure, it's different cases. There are different layers that need to be considered. And the second about a delay in trial, I think the court has referred to that, saying very clearly that can't be a trump card to go ahead and secure bail. And that's something the court has said. You have 3 different courts. You can talk about benches as much as you want, but 3 different courts, when they all align saying that, look, the case has been delayed because of the accused, then where's the question of the bench there?
Till now, no, but the 3 different courts till now, till the time it reached the Supreme Court, clubbed both Sharjeel as well as Umar, along with the 5 others. The distinction of a different, but the distinction of a different footing. So the distinction of a different footing was only made by the Supreme Court. So till the Supreme Court, so you can't say that 3 different courts, because the courts, two earlier courts dealt with the case very differently than what the Supreme Court
has. So where the 2 different courts are concerned, sure, they clubbed everyone. There was no distinction made between the other accused, but a delay is a delay, irrespective. What I'm referring to is the aspect of the delay in the trial.
Delay where these 2 are.
And in that case, yeah.
Where the prosecution holds them responsible.
Yes.
But then on the other account,
the delay is attributable at least in part to the conduct of the defense.
That's what we were speaking of.
Same case, same trial, records are the same, procedural background is the same, and yet different
delay at part,
or orders.
Delay at part, you're very right, the both of you, is on the account of the accused. But how do the accused come into delaying a trial where the witnesses haven't been interrogated, questioned, number one. Number two, allow me, right? Haven't been questioned. And number two, the charges haven't been framed. And what the court said, that we'll give you 1 year. Or if the witnesses are interrogated first, whichever one comes earlier. So does automatically after 1 year Article 21 kick in? How does it really happen?
May I weigh in on that aspect, please? So, see, which is why in my opening remarks I said, whether you look at this case in particular or the larger question of how we're looking at bail. In this case, if you look, since we are debating this particular matter, the court is looking into three things. One, is there violation of the constitutionally protected right to liberty by a delay in trial? Who do you attribute the delay in trial to? And other than that, what are the circumstances, facts, etc. in this particular case which justified grant or non-grant of bail? Now, in this particular case, why the court has chosen to take the decision that it has is that it is recognizing, and I'm going to quote something here, that delay can warrant a more searching constitutional scrutiny but does not authorize the court to dilute the statutory threshold by undertaking credibility findings. The balance must be maintained. Constitutional concern is real. This court is also accepting the fact that yes, it has been 6 years. The constitutional concern regarding delay, for whatever reason the delay has happened, is real. And
But
more importantly,
however-
sorry Gaurav, let me just finish this point. This court and every other court which is looking into the question of delay versus UPA bails is not looking at who is causing a delay or not alone. What they are looking at is there any possibility or probability of the trial actually concluding within a reasonable time? In this case as well, what they've noted is that there are about 900 witnesses. There is even charges have not been framed. For whatever reasons, there have been multiple adjournments. But there is no hope whatsoever of the trial concluding within the period of 1 year.
1 year, exactly.
So
And which is
delay cannot be examined in isolation. Delay alone does not entitle
is
a person
exactly
to
what
a
I'm
bail.
saying.
The right to speedy trial, that Article 21 that you refer to, is important but must be balanced when it comes to your national security. So you cannot take national security a
Fair
very
point,
critical
but
issue.
Gaurav, that's
If
what
a
I'm saying.
person is
Okay.
enlarged,
That's what the
if a
Supreme Court-
person is enlarged, would he do the same thing again? And would you risk national security?
Gaurav,
Would you
there
risk
is,
lives
like I
being
said,
lost
that-
just so that he has liberty?
Okay, allow her.
Since we're reading from the court order here, can I also highlight that the bench said a delay in trial is not a trump card that can be used to displace statutory safeguards. The Constitution guarantees personal liberty, but it does not conceive liberty as an isolated entitlement detached from the security
All right.
of the
Okay, so
society.
because, now I'll give you an example and why we say, and with what Anisha also began, that there's a fair amount of confusion when the benches come into question, hearing the same cases like UAPA. Now, where a person was incarcerated for a year and a half, you had the Supreme Court bench, because you read out, let me read out, say, it is very well settled that if the court or any prosecution agency, including the court, has no wherewithal to provide or protect the fundamental rights of an accused to have a speedy trial, the state or court should not oppose the plea to bail on the grounds that the crime committed is serious, including
No,
UAPA.
but what was that individual's
including
crime?
UAPA.
What
terror,
was-
terror,
what
terror.
was-
terror.
what was his
Like I
crime?
said,
What
no,
was-
it is the interpretation.
No, but
allow Nalini to come.
the degree of his
A
crime,
basic
the degree of his
difference, yeah.
involvement,
Like I said.
everything matters. Those on the periphery were given bail. Those at the heart of it
Well,
are
he
not
was
getting
charged
bail.
by UAPA, he was charged
But
with
UAPA
anti-terror
has different
activities.
sections.
Go ahead.
UAPA has a very special section I want to talk about that the Supreme Court's also spoken about in
Right.
length, okay? It talks specifically about bail, and it's a negative section that says that judges have to ensure that in cases where a prima facie case has been made out, they should not grant bail.
Right.
This is a law that has been laid down in the UAPA. The question that arises is that should courts and should judges, I don't think it's so much about different benches or different judges.
As it is being made out to be by some, which is very worrisome.
I think it's
disharmony,
more about-
disharmony against our courts should be
No,
unacceptable.
I'm sorry. I'm sorry.
may
No
I
institution in this
step in
country,
here?
Gaurav, no
You
institution
can
in this
question a
country is
judgment,
beyond question.
but you start questioning judges and
institution.
motives is very uncalled.
Nobody's not. Who's how
nobody's
is
You know,
questioning
now
that is
judges and
unquote-
motives?
that is-
No.
that is
Gaurav, you're making a very
unquestionable.
great
Specific
charge.
bunches-
Who is questioning? 1 second. Who's questioning motive? Who is
I'll
questioning motive?
I'll tell you, when you're suggesting that one bench, interprets it a certain way, another
not
interprets
motive.
it another
What
way.
is
That's
not
it.
motive?
Then what is it?
You're causing
Let me just
confusion.
vein. Let me just vein on
It's
that.
causing
May
confusion,
I
it's
answer
not
that
motive.
question? May I answer that
That's a
question?
bizarre statement
One
to
bench
make.
does
about
this,
motive.
another bench
No,
does that.
Akshata.
That's
What do you
said,
say?
Anisha.
I'm explaining exactly
Please
what I
do.
said. The judiciary, as Nalini said, has the right in a UAPA case to
Exactly.
examine the evidence and interpret whether there is enough balance in favor or against the accused. Now, when you're talking about the discretion of the person who's sitting on that chair, you have liberal
Exactly.
judges, you have more conservative judges.
Exactly.
That is something
It's-
that happens.
It's the magnitude of a crime of an
No,
individual.
it's not a
You
benchmark.
know,
The magnitude
I-
is
I-
suggesting
Okay,
we are going
liberal
to
versus conservative.
one by one.
On a
One by
very
one.
simple,
Let's
it's a
go
very
one by one.
simple
Allow her
point.
to finish, I'll
If
come to
you
you
look
after that.
at the way courts look at bail, whether it's UAPA, PMLA or bail in general, there are certain judges who put more emphasis on the issue of delays, on the issue of liberty, rather than saying that, well, I am not going to give you any...
It's in their wisdom, and that's why
Exactly.
the
So
Supreme
one
Court
bench
judges.
differs from the
So,
other. That's what we are
of the
saying.
judge
depends on
Without
the crime.
attaching motive.
No,
I'm
allow,
saying
okay,
it's
Anisha,
a
allow.
crime
a
committed.
polyvocal court, which is what the Supreme Court of India is, that the same three different judges may have three different opinions about the same
Exactly.
set of facts. We are, and I'm not saying this to criticize the court, I'm saying this with the help of analysis of the last 39, 40, 50 cases where in the last 2 or 3 years where courts have either given or not given bail. There are judges who
Okay.
err on one side where and some
You know that
who go to the
section
other.
40
43D5,
Gaurav, allow
that
Akshita.
43D5 is very clear on when bail is to be given and what circumstances
But it
and what
doesn't
is
work
the
like
role
that,
of
Gaurav.
a
That's the problem.
particular
It doesn't
individual.
work like
I don't
that.
know if we can say things like conservative versus liberal judges. Honestly, because to one person it may be conservative, to another not so much.
Akshita, I'm not talking about political ideologies when I say
am not talking
conservative
about
or
political
liberal.
either, but I'm
on the
not
suggestion of
saying,
liberty.
my suggestion is interpretation of the law is all you can talk about,
Of
right?
course, and that is exactly what I am talking about. When you're talking about a set of judgments, and I'm talking about a very, very simply that
I'll
when
come
you
to your
have
points.
judges who, when you have a system which allows a judge to weigh on their own conscience whether they want to give more weightage to the question of delay and liberty, or they want to give more weightage to the seriousness of the offence, which, by the way, Gaurav, is what the section 43D allows
Right.
them to.
Absolutely.
That
Go to a
prima
superior
facie
court.
look at-
Go
No,
to
but
a
it has
bigger
one second in.
bench.
It has also happened that in the Supreme Court, one bench has turned the judgment of another bench. So that
Of
means
course.
it depends what bench
which
you
is
get.
precisely
No.
the
Okay,
point
one
I'm
second.
making,
Okay,
that
allow
we have
Akshita.
a polyvocal Supreme
done?
Court.
Okay.
We
Nalini.
have a situation where
Okay,
there are different judgments.
Anisha,
coming.
allow Nalini.
No, so like I was saying, I don't think it's so much about which judges are listening to your case. I think it's more about, so there are two things. There is the letter of the law, then there's the spirit of the law. Even in the Kuldeep Singh Singer case, we saw that the Delhi High Court had suspended his sentence. And the judge had followed the letter, of, the law. Kuldeep Singh Singer did not fall under the definition of public servant according to
To the letter of the law. Yes.
Precisely. So you can criticize it as much as you want, but at the end of the day, you've entrusted those people to sit on those chairs and make those decisions. Similarly, in this case, when the judges say that we've gone through the evidence in a prima facie manner, not just the Supreme Court judges, even the judgment given by the Delhi High Court by Justice Naveen Chawla has spoken in detail about the evidence, the witness statements, the WhatsApp chats, everything he's gone through, after which he's come to the conclusion that they were, I think he's called them the intellectual architects of the entire conspiracy. But I'm saying that once you've entrusted them with that, and when they say that according to the law, we believe that there is a prima facie case and they should not be allowed out on bail, then that's the judgment that you have to respect. At
And
the
it's
end of
gone
the
through
day.
multiple
After-
levels of scrutiny, if I
Precisely.
may.
After a year from now, they are of course not expecting for the trial to end. I don't think they're even expecting for the trial to begin in a year
year's
from now.
time, yeah.
But they've
It's
said that
already 6
as long
years.
as the protected witnesses, and remember this,
Okay.
okay?
I have 2
fact
minutes.
that protected witnesses
Gaurav, you have
might
30 seconds.
be influenced is a very big
Okay,
reason.
Nalini, okay,
to
30
deny
That's
seconds.
one part of it. Whether they influence witnesses, two, are they the intellectual ideologues who may do it again and lead to loss of life, property, or adversely impact national security? So national security is far more important than their individual liberty.
Okay, 30 seconds.
It may have been 5 years since the riot, but we have to remember the serious charges that they face. You know, there may be sympathists who question, 5 years they've been languishing in jail. How can they not get bail repeatedly? This is the law of the country. You have to follow the law of the land. If there are serious charges against you, they've appealed, they've had a chance to appeal, as is their right in every single court. If they've been denied bail, it's for a reason.
And the
Okay,
same
one
legal
second, I
system
don't
was
have the time, one
absolutely
second.
silent.
Just to add to what Akshita is saying, you might have a problem with the law, but the solution to that is challenge the law.
Okay,
yeah.
In a
Don't-
superior
and
court.
Anisha, you
don't
have
criticize the
I
judge
don't
for
have the
allowing
time.
that.
Anisha, make your point.
I'm just making
Anisha,
one
make your
small
point, yeah.
point. Anything I've said today has nothing to do with this case in
Okay.
specifics,
Exactly,
but the
we're not
question
here. This is a
that
larger
we
question.
have a polyvocal court. We have a system that allows a judge to take a decision as per their own conscience, and that is why we have, and this is an analysis, not my opinion. We have a situation where in the case of a UAPA or a PMLA or a general bail,
Right.
we are getting different
Okay,
judgments from
different
different
judgments.
And
benches.
if I
Okay,
may, last 30
great.
seconds,
You're
those
a
who are so
democracy.
vocal
Okay, one
about
second.
these two individuals were so silent when it came to Colonel
Okay.
Purohit in an
All right.
earlier time who was in jail for 9 years in similar
Okay, point
or
made.
other
I am running out of
circumstances.
time.
years. In the case of
Okay,
terror,
I'm
5
not.
years.
Okay,
Yeah.
we're running out of time. We need to go on to the next show. So, well, ultimately, the larger question is that the Supreme Court has been on crossroads with its engagement where liberty is concerned. Whichever way you might want to interpret it, it's not about bail as such or the denial of bail. What I would think is the tragedy is that the reasons which are varied of denial of bail in the same charges. And that is open to discussion, which we did
Sure,
right
but why
here
is it a
on the
tragedy? It's a
Democratic
national
Newsroom.
security case.
Well, that's what I feel. All right, with that, a quick break to stay with me on the other side is to the point.